Hello, I'm David Roger, General Counsel for Las Vegas Police Protective Association. In this video, I'd like to talk to you about serving protective orders and the Fourth Amendment. And so, as you know, NRS 33.060 requires police officers to serve temporary protective orders and extended protective orders. And so, the key to this entire discussion is to remember, with due respect, that you are acting as the process server for the court. This really isn't police action. This is just serving process. And I suspect that lawmakers recognize that these protective orders are generally dealing with domestic violence situations. It could be a dangerous situation, and that law enforcement interaction with an individual might de-escalate the situation. Not always, but I think that's probably the idea. And so the statute doesn't require you to go to extraordinary efforts to serve process. The statute, generally speaking, requires you to attempt to personally serve the individual. And after 3 times, if you can't personally serve the individual, then you place a notice on the person's residence, giving them 24 hours to contact you. If they don't contact you, then the report goes back to the judge who issued the order. At that point, the person who requested the protective order can go back to court and ask the court to issue a new order, but also direct you to go to the person's workplace to serve them with the order. And then after a reasonable effort, if you can't serve the person at their job, then the court can issue notice through the newspaper or some other device. And so you're just serving process. So let's take a look at the Fourth Amendment. So there's a case called Soldal, S-O-L-D-A-L, versus Cook County, 506 U.S. 56. In that case, deputy sheriffs were asked to assist with the eviction of an individual, the repossession of a mobile home. The people who were repossessing the mobile home had not waited for an eviction order, and so they were just doing it because they believed that an order would eventually be issued, and the deputy sheriffs were asked to keep the peace. And so when the occupants of the mobile home asked for assistance, police said that they were not able to help because they're there to keep the peace. And the U.S. Supreme Court said that the Fourth Amendment applies, and even though the police officers were acting as standby, they were alleged to be co-conspirators of the people doing the repossession, and therefore, because it was arguably an unlawful seizure of the mobile home, the Fourth Amendment applies. And so what that means is that with respect to your interaction with individuals in serving protective orders, the Fourth Amendment applies. That doesn't mean you can't follow court order. It just means that we have to be particularly careful in doing so. So let's talk about going to a person's home to serve the order. This is a civil process, so you're not going to the residence to arrest the individual. You're not going to take police action if they refuse to answer the door, or they answer the door and then they close it on you. All you're there to do is serve them with a piece of paper. And so, in my opinion, Florida versus Jardines applies. It is a knock and talk. And so just as a process server could go up to the individual's home, so can you. You can knock and talk. If they don't answer the door, NRS 33.060 says that you call it a day and try it some other time, and you go through that process. So if you were just going through the process and doing a knock and talk, in my opinion, you are safe and you're not violating the Fourth Amendment. It's civil process, and so the rules concerning curtilage and the Peyton rule as far as arrest, none of that applies. You're just going up there to serve process. Well, the next question comes up as to whether you can stop a vehicle if the registered owner is the subject of a protective order that has to be served upon them. And in my opinion, unless you have an independent basis for stopping the vehicle, a traffic infraction or some other criminal violation, it is a Terry stop and you can't stop the vehicle. You can follow the vehicle and wait till it stops and approach the driver, but you can't detain them. You can't take police action in order to serve this process. And so with respect to vehicles, unless you have a basis to stop the vehicle, aside from having to serve a temporary protective order, don't do it. And then finally, let's assume that you have made a lawful stop, a vehicle stop. The person has run a red light or there's some traffic infraction. The question is, during your routine process of issuing a traffic citation, running a records check, can you then issue the temporary protective order? And so, as we've discussed in the past, Rodriguez versus United States 575 U.S. 348 allows officers to do routine record checks, ask for registration, proof of insurance, and that type of routine work as part of your temporary detention without unreasonably prolonging the stop. And so the U.S. Supreme Court and the Nevada Supreme Court in another case has held that officers are not unreasonably prolonging the stop if they're doing these types of records checks because, in part, it's for officer safety. So as part of the records check, if you find that the person has a temporary protective order, in my opinion, you're not unreasonably prolonging the stop because it takes maybe 2 minutes to fill out the form and hand them the protective order. And I can't imagine a court holding that you have unreasonably detained the person. And probably more importantly, as you know from our discussions, unless you are violating a clearly established law, you're still going to get qualified immunity. And so in my opinion, you can serve the person with a protective order without violating their Fourth Amendment rights. So that is the service of protective orders. Just kind of keep in mind that you are a glorified process server, with due respect to you. That's what the lawmakers up in Carson City intended for this to occur as a result of the passage of this statute. Knock and talks, fine. Consensual encounters, fine. Terry stops if it's for a traffic infraction or other legal basis, criminal basis. And once you have stopped the vehicle based upon a lawful vehicle stop, you can issue the protective order without violating their Fourth Amendment rights. As always, thank you very much for listening. Please subscribe to our YouTube channel so you get these videos in a timely manner. And as always, if you have any questions, feel free to contact me at droger@lvppa.com. Thank you for listening.
111, 110.